Jon has experience litigating in a wide range of federal and state courts. He has argued dozens of appellate cases in Kentucky and federal appellate courts, including numerous appearances before the Supreme Court of Kentucky and multiple different U.S. courts of appeals. He has a substantial experience in state and federal courts around the country.
In addition to his law practice, Jon remains active in the community. Jon currently chairs the board of directors of the Jewish community of Louisville. He has also received numerous community awards, including the National Council of Jewish Women's David Ricart Award for outstanding service to the welfare of Kentucky's children, as well as the Department of Public Advocacy and the Louisville Jefferson County Public Defender Corporate Pro Bono Service Award for his support of the constitutional rights of the poor and needy of Kentucky. He also is the only non-journalist to have been inducted into the Kentucky Journalism Hall of Fame. Jon and his wife, Kim Green, also created the Fleischaker Green Fund for Excellence in First Amendment Issues at Western Kentucky University. This program gives journalism students the opportunity to take an advanced special topics class once a year and bring nationally recognized speakers in journalism and First Amendment issues to WKU.
We bring on experienced lawyer Jon Fleischaker. Feel free to introduce yourself, and let's go right into this oral history of open records.
Okay. I grew up in Louisville, went to public high school in Louisville, went to Swarthmore College, Swarthmore, Pennsylvania, went to law school at the University of Pennsylvania, came back to Louisville to practice law, joined a law firm that represented most of the media in Kentucky. What I'm talking about now is 1970. That's 54 years ago, almost 55. And I got involved very quickly in a case that ended up in the United States Supreme Court called, it's the Brandsburg case. And it dealt with reporter privilege, not to disclose information about sources. I was 26 years old when I got involved in that. I was 26 years old, sitting second chair, actually, in front of the Supreme Court of the United States. That put a lot of what my professor said is I would not have an interesting practice in Kentucky. Anyway, I found out that I really liked it. I really liked it. I believed in freedom of the press, freedom of speech. I believed it not only in my head, but in my gut, which is important. And I also really liked dealing with reporters. And I found out I really liked being with reporters more than I liked being with lawyers. And so I got the opportunity at the Courier-Journal at that point, which at that point was the most powerful newspaper in the state of Kentucky by far. A family owned it, the Bingham family, and I started doing work again when I was 26 years old for them, and by the time I was 28, I was basically the lead lawyer for the Courier-Journal. Barry Bingham Jr. Was the publisher of the paper. He and I got along great. He gave us all sorts of opportunities to do stuff, and it was when I was 28 years old, been practicing law 3 years, that I was asked to start writing, open records law. Open meetings law, and then 2 years later we wrote the open records law. I participated in writing the open meetings law. I participated in some of the legislative efforts, which are much different than they are today. In those days, the governor dictated what was going to happen. We had a commitment from then Governor Ford on the open meetings law. Then I was asked specifically to write the open records law in 1975. The decision had been made, at least by us, to do it one at a time, to do the open meetings law. There were there were several veteran reporters who did not want the open records law. Thought we would have they could get anything they wanted from sources. that it would just hold it up. I think history has proved them absolutely wrong. The open records law has been extremely valuable, extremely important, and so has the open meetings law in a different way.
Can you talk about first the importance of these laws and then why they face so much opposition from not only law enforcement but also universities?
When we started talking about open meetings and open records, understand it was an entirely different environment, political environment, than it is today. It was an environment that was shaped by the civil rights battle. It was an environment that was shaped really substantially by Vietnam, the war in Vietnam, the Pentagon Papers case, which disclosed a lot of information that the administration did not want disclosed, was very, very valuable, and there was really not unanimous, but there was a consensus among the lawmakers, at least the General Assembly, to go forward with more transparency. We had none at that point, none. So both laws have a preamble, that talk about the importance to the public of knowing, if you'll pardon my language, what the hell's going on with government. Not just with state government, but with local government and all so-called public agencies. So we had a substantial public approval. The opposition really came from open records, not from open meetings. The opposition came when we sat down and tried to write what records we were entitled to. Open meetings really deals with the meetings of the governing body of a public agency, and they were used to being open, at least partially. Public agencies were not used to having to respond to citizens, residents, asking for records, and there was real concern that, not legitimate in my mind, but real concern that would be a detriment to how they effectively function. What I was really surprised about, what I've been surprised for 50 years now, and disappointed, is that we assumed that law enforcement would be against it, and they have been consistently against it, and we have fought every battle every year, it seems, with law enforcement records. But I have been surprised and disappointed at the consistency that universities and colleges have been against it. We have consistently been negotiating and been at the table, lobbying or whatever, and universities have either directly or indirectly really tried to shut it down. I think because universities are very ingrown communities, and administrations of universities really feel like it's theirs, not ours. They're wrong. But we have fought and fought. There have been major cases against the University of Kentucky, which we've won. There have been major cases against the University of Louisville, which we've won, and we continue to fight. They are continuing. It is a day-to-day happenstance that we will get calls. I will get a call saying the Board of Trustees is trying to avoid and evade the open meetings law. They're meeting off campus. They're meeting at different times. They're trying to play games with this. That continues to be the case. With boards of trustees, I've always thought you're dealing with a lot of members who own companies themselves, been very successful. That's how you get on a board. And they feel like it's none of our business. They'll make the decision. So that's a constant fight. And again, we not only fought with UK, because we've had some really fun cases with the University of Kentucky. Western's been a real problem. Eastern Kentucky's been a real problem. Had some problems at Murray. Kentucky State has had problems. It's par for the course, and I've just gotten used to it at this point. The cases with UK and University of Louisville were two of the biggest, several of the biggest cases that I've had that really have been fun because in the business that I'm in, you not only get feedback from the courts, you get feedback from the public. And the public wants to know what the hell's going on. And I've always been a big believer that the media ought to exercise its franchise and its constitutional rights and tell the people not only what's going on there, but the efforts of public agencies to close their meetings and to close their records. I think that's really important. It's more difficult today because of the media is spread out. It's people get their information from a variety of sources. From the first 35 years of my practice, 40 years, it really related to newspapers and broadcasters.
So just to get on a yearly timeline, right? 1974, open meetings law enacted.
Right.
Okay. Open records law enacted what year?
1976, and it's interesting that I'm smiling as I say this. I was very young, and I was involved in some of the stuff. But in '74, I always thought, I know the decision was made in Louisville by the Binghams, and the Binghams ran the Kentucky Press Association also at that point. They were the Courier-Journal was really, it was a great client to have because it was really powerful. The Binghams had decided to do it one at a time, open meetings first, and then because of the opposition of several of their veteran reporters, we'd wait. We actually did a test case to see what we could accomplish under the existing law. It turned out we can't accomplish much. And then after open meetings, we decided to go with open records. I did not know until this year that there had been a open records law passed in the '74 legislature, General Assembly, which was vetoed by Governor Ford, I believe. My supposition, because I know how I got the job, is that a couple people tried to pull one off, and the KPA, Press Association, and the Binghams had other ideas. So Ford vetoed it, and then I could remember the day when I think I got the call saying, we want you to write the open records law. I'm 28 years old, and I worked with one of the actually the assistant to the executive editor, a guy named Bill Cox, who has been dead for a very long time. A great guy, great sense of humor. But I sat down and I started looking at Freedom of Information Act, other laws in other states, and we started writing something which was basically a wish list. What would we want? And that's how we came up with it. And then we sat down and did some negotiation in what was then Governor Carroll's office, and it passed easily. I know when I was doing the work in the governor's office on the bill, Tony Wilhoit, who became a Court of Appeals judge, was representing the state police, and he was in there, and we had some interesting conversations. He did a nice job, but that's how we came up with it, and it was a wish list, and it's held up pretty good. There were amendments to the law in 1992, both laws. That's an interesting story, but they were really good amendments, which we tightened it up. And because of those amendments, we were able to, for example, fully litigate the issue of whether foundations of universities were public agencies. University of Louisville said they weren't. We said they were. We filed a lawsuit. Basically, the issue what we filed on was we thought that Senator McConnell was using he had started the McConnell School at the University of Louisville, and we thought he was using that. People were contributing money to that to get access to Senator McConnell in his position as a leader in the Senate. So we wanted to see all the donations. And when we filed suit, Senator McConnell said it was a frivolous piece of litigation. We would never win. 6 years later, we won. My friend and then editor David Hopp spent the next 25 years trying to get McConnell to admit he was wrong and to apologize, but we never accomplished that.
Let's go into those amendments that you were just talking about. There's 3 that you have given us. They expanded definitions of public agency, expanded enforcement to give more weight to AG opinions, and expanded definitions of meetings to include series of meetings less than a quorum.
Right.
Go into those, expand on how this also shaped the open records.
Okay. What happened in 1990 was there was a push in the legislature really coming out of northern Kentucky to really drastically change the open meetings law and the open records law because a couple of those legislators had been caught. And the bill came up in the 1990 General Assembly. And as a compromise, David Thompson, who was and still is the CEO of the Press Association, suggested that that the General Assembly do an interim study from 1990 to 1992, because in those years it was every other year, the sessions, and they appointed and they established a interim committee of legislators, and then with three or four outside advisors or participants. I was one. A guy named Stan McDonald, who was a great investigative reporter at the Courier-Journal and then an editor, was the second one. And Steve Lowry, who was a terrific journalist out in the state, representing small newspapers. At that point, he was either in Bardstown or ended up in Bardstown. But and we were on the committee. And we started going through this stuff and dealing with, and it was really valuable that we were there because we could tell them after 15 years of dealing with open records, here's the problems we're having. We were having a serious problem with the definition of public agency. It was not broad enough. We broadened it to cover things. We hadn't written the definition, for example, to cover probably didn't cover university foundations. It certainly didn't cover joint where counties work together. So you had a zoning commission. We had real problems with that. So we wrote an expanded definition of it, and everybody agreed. I mean, we got that agreed to. Really instrumental in my lawsuit against the University of Louisville Foundation. We would not have won that because, or at least we would have had a much more difficult time winning that if that definition had not been changed. We had continuing problems in Louisville with the Jefferson County schools, the Jefferson County School Board. They were trying to evade or avoid open meetings. They would have a series of meetings the morning of a public meeting of less than a quorum. Meetings defined as a quorum of the governing agency. So the superintendent would call 2 members in, talk to them, get their approval. They'd leave. He'd call 2 other members in over a period of a day or 2. Just a series of meetings. That's a huge problem. I think it's a problem that still exists, by the way. But in 1990, we got the law changed to expand the definition of meetings in a quorum to include a series of meetings meant to avoid a quorum. So you still see it today. You see a lot of it. Board will come in, unanimous vote on a controversial issue, no discussion. Well, that's BS. I mean, they've talked about it. And the thought was that needs to be public. That's part of the process. And that's what both open meetings and open records are really important, because it's not just we need to know the results of what happens, we need to know how it happened. And that's been really, really important. The third issue that we dealt with that was really important is we were getting favorable opinions from the Attorney General. Now, the Attorney General, going to the Attorney General, it's not unique, but it's different than in most states. In 1995, when we wrote the open meetings law, we thought we needed a way for a quick decision. And my feeling was it would be an issue, it would be a process that didn't necessarily involve lawyers, so that anybody could do it, because the expense of a lawyer stopped a lot of people from moving forward. And so we came up with this idea that the Attorney General would do it. And up until the last 6 years or so, it's been very successful, because not perfect, but it's been very successful. It's when we've gotten into the political atmosphere, political environment that we're in now, that it's not so successful. Cameron was terrible. He tried to change the law with his decisions. But we would get a decision from the Attorney General, and then the board would say, "So what? What are you going to do with it?" So we had to file the lawsuits, and those are expensive. So the committee decided, with our suggestion, that we make the Attorney General's opinion binding on the agency and binding on the person asking for an opinion if within 30 days there was not an appeal to circuit court. So what it did was it forced all these agencies to bring lawsuits themselves. Sort of nice if you're the lawyer, but what it did was it got the courts involved. And one of the things I will say, and it's still pretty much the case. It's not as good as it used to be. Kentucky's a great place to practice First Amendment law, because most Kentuckians believe that government shouldn't be involved in most of their decisions, and they want to know what those decisions are. So once we got to circuit court in many cases, and of course judges are elected, we've had great results. That's changing now. But we didn't have social media at that point, and we didn't have the kind of situations and environment that we do now. But I will tell you that the definition, we go back to definitions, because we changed the definition. We not only got the enforcement, which has been very successful, by the way, and led to some damages being awarded in many cases when the agency didn't follow what the Attorney General said. But it was a situation where we were able to well, I'll just leave it at that. To get damages and to get cases up to the Supreme Court of Kentucky, which has been very successful.
So you've talked about the laws that have been enacted and the amendments that have strengthened them. And I was wondering if you could move into the significant cases, specifically ones involving the open meetings law. So you mentioned earlier the University of Louisville Foundation, and they had one case involving, I believe it's the Courier-Journal. I was wondering if you could talk about that.
I'm sorry. Tell me. The Courier-Journal and University of Louisville.
Yes.
The biggest case was the one I had mentioned previously. Was the case we filed because we wanted to know who's given money to the McConnell School. We had two problems. One was we had a definitional problem. We solved that. With the amendments. We had a problem. We asked the University of Louisville for a list of all their donors and how much they donated. And any other file, any other, why did they donate? Were there conditions? You know, you're going to teach a course this way, you're going to teach a course that way. People donated major amounts of money for basketball tickets. We do live in Kentucky. So at U of L and at UK, that was an issue, and they kept raising the issue of privacy, because there's an exemption, a broad exemption. It's not broad. The burden is on the agency to prove an unwarranted invasion of personal privacy. That unwarranted was I wrote that in the records because it's too easy. People misunderstand what privacy is. That was a case against U of L where they said we weren't a public agency. We litigated that part of it, went up to the Supreme Court, and got a terrific decision. One of the best questions, I've argued, 50 cases in Kentucky Supreme Court. The best question I ever heard at any Supreme Court argument, it was Justice Cunningham from southwestern Kentucky, who asked the university lawyer or the foundation lawyer, why aren't people entitled to know who's giving money? And he argued privacy, and Cunningham said, well, what if I'm a black parent and I have kids who want to go to school there and study history? Isn't it important to know who's paying for it? You know, how are you teaching the Civil War? How are you teaching? It's the same argument we're having today about civil rights and how do you teach it and how do you teach all the history that we've gone through? And so if my black son goes to UK or U of L, excuse me, it's against the U of L, and wants to study history, shouldn't he know who's dictating what kind of history you're teaching and how you're teaching it? The lawyer said, no, it's a matter of privacy. I turned to my partner who was with me at that point and said, we just won this case. It makes total sense. It's a great question because we found out, you know, a lot of things about not just that, but we ran into instances where the Klan was involved in police enforcement, and that was another case which I actually lost, but it was a great case and accomplished its purpose. But that's Supreme Court. I think it was unanimously said they're a public agency because it's sometimes it's really easy to argue because you can say obviously it's part of the university. Come on, use common sense, and that's held for a long time now. Then the case was remanded to the circuit court on the issue of donations because we wanted to see who gave money. I had a list. We had under discovery. The university. We asked for the list of everybody who had given money to the McConnell School because. And before the court decided anything, I was given a copy of that list with the understanding I would not disclose, but I needed to know who these donors were to be able to you could argue in terms of generalities as opposed to specifics. Well, there were several donors from Greece. There was one from Greece, gave a substantial amount of money. Well, with all due respect, I don't think anybody in Greece is particularly concerned about the McConnell School. They obviously were looking for access to McConnell. There were others. Now, there were other things like basketball tickets. They didn't want their name given out. They didn't want their wife to know how much they spent for tickets. And we went back up to the Supreme Court, and again, a very simple argument. We're entitled to contracts. The public from the beginning was entitled to contracts of all public agencies. That's a contract. I'll give you money if you do this for me. The court agreed. But the court said since it was undetermined when we initiated the lawsuit, that the names that were given, that the people who gave to the McConnell Center that we were trying to get, those would remain sealed. But henceforth, all donations are public for any public agency, not just for universities. And that's, excuse me, that's been a major, major benefit. Where's the money come from? That's really, really important. And it is amazing how often people want to fight that and how they want to do it. So it's been a terrific decision, and it's an easy one. It's an easy, the concept's really easy. It's really a secret to how you practice law. Make it simple. So that was a terrific example. We've continued to have problems with the records of the university. It just, and with other public agencies, but we cite this case really a lot. It's been a great case. So that was the one against the University of Louisville. There have been cases against University of Kentucky. I think the University of Kentucky probably has the worst record in the state for trying to avoid open records and some open meetings, but mostly open records. The big case was the case involving Title IX, access to records involving a professor who had been disciplined, was having sexual relations with several students. And that was a story written by the Kentucky Kernel. And it was a really good story. And I know it because I helped the Kernel go through that process. And the women who had been abused came to the Kernel. It was voluntary. They disclosed the information. And the university kept saying it's an invasion of privacy. Well, it's not an invasion of privacy if somebody comes to you and talks to you, understands you're going to publish it. That case, UK got shot down badly. They've been shot down now on other things. I really like the president up here, but he's been terrible on transparency. He's been terrible on, he has a misunderstanding in my judgment on what privacy is all about. But we hear privacy on every case. We've heard it for everything from Title IX. What was happening was the UK is not alone on this. They were resolving these Title IX cases by letting somebody resign with the understanding we won't tell anybody else what happened, so that when they applied for a job down the road at some school, the university was not telling them this guy had, and it's usually a guy, this guy had real problems, and he was, and we have records that show he was violating Title IX. References are really important, and recommendations, and the universities and businesses really look for the easy way out. Just get out of here and we won't tell anybody. So that was a big case, very big case. I'm trying to think in terms of probably the most fun case I've had against the University of Kentucky. Really started out as open meetings and then evolved or devolved, depending on your viewpoint, into an open records case. UK had received an allegation that warranted sanctions on its basketball program. Now I'm going to get screwed up on dates, so and I apologize for that. But this was when I guess Sutton was the coach. But anyway. UK did an investigation, and they were going to have a board meeting on a Sunday, and to decide whether to approve the response to the NCAA and send it off. And they were going to close the meeting, and we filed suit. maybe on a Thursday before. We had a hearing in Lexington, here in Fayette County Circuit Court, Fayette Circuit Court, on Friday morning, and the circuit judge said it's open. That meeting should be open. There was an immediate appeal that day to the Kentucky Court of Appeals. At 6 o'clock that night, the Kentucky Court of Appeals said the meeting should be open. And they immediately appealed it to the Supreme Court for a temporary order to stay the Court of Appeals. We argued that in front of then Justice Lambert, who became the Chief Justice, 10 o'clock at night on a Friday. And at 2 o'clock in the morning, we got a decision. He said, it's not open. He stated. So then UK decided to open it. They approved it. I'm not sure they opened it. Anyway, they approved it and they sent the response back. We then filed an open records request for the response. And they said, no, you can't have the response. It's not final. It's not final until the NCAA rules on it. And the NCAA, part of their regulations, say you're not to make any public statements or release any information. So we filed suit, and we got up to the Supreme Court. That case, the Supreme Court will occasionally go to other venues to argue cases. I argued that case at the University of Kentucky Law School. Packed house. It was the law school's been rebuilt or rehabbed or whatever, but it was about 300 people in there in the auditorium. It was really great fun. They come out. The justices come out. This is just a little aside. The justices come out and say, we got a problem. We need to seek counsel in chambers. So we go back, and the Chief Justice, this was not Lambert, the Chief Justice said, we just figured out we have a problem. We get free tickets to all the University of Kentucky games. Or do you want, do you want to, deal with that? And I don't know how you deal with it. I didn't want to go to, I didn't want another 3 years of stuff. We were ready to go. So again, it's nice to be in a small state where you know everybody, because and I turned to Justice Leapson and said, I'm fine. I said, but I really would like Justice Leapson to be able to give me the tickets to the UK game. Everybody laughed, and we went back out and argued it. And the court gave a terrific decision with two really important points. One is, it was a final action by the board. It didn't depend on NCAA acting on it. They took a final action. We were entitled to see the results of the final action. With regard to the NCAA rules that, and regulations say you can't disclose it, they said, NCAA is not state law. NCAA follows our law. We don't follow the NCAA. You can disregard with the NCAA. We don't care. And that has been an extremely important decision because that we cite all the time for situations where people say, we made an agreement with the other side not to talk about it. We don't care. It's a wonderful decision. All these situations where there's been the two parties get together, they say we're not going to talk about it, or it happens all the time with recruiting, with presidential searches, where we've agreed because the people don't want their names disclosed that we're not going to disclose their names. Well, that's not up for you to decide. If it's a final decision, we're entitled to it. So that's been a decision arising out of a basketball situation that's had statewide implications and continues. And I never really realized it when it happened, but we kept citing it, and I said, geez, this was a pretty important case. So that's the other one I keep thinking about.
Can you bring up the Brandsburg case? What was that about? Why is
the
this
Brandsburg
important?
case? It sounds quaint today, really quaint. Brandsburg was a reporter for the Courier-Journal, and he wrote a story. I think in 1970, he wrote a story. That's the year I started practicing law. Brandsburg was an interesting guy by himself. But anyway, he wrote a story about a guy in Frankfurt who was selling pot, basically, from the Capitol. And it just, everybody was, he got subpoenaed, actually in two different courts, but he got subpoenaed in Judge Hayes' court in Louisville to testify and disclose who he witnessed, because he had been there. He had seen the guy mixing this stuff up, not just hashish and all this, whatever. I'm not an expert on this stuff, but he had been there and he had seen the guy do it, and we moved. And again, I was second chair at that point, but I'd been practicing law a year. And we went from the circuit court to the court of, there was no court of appeals at that point. The court of appeals was the Supreme Court before this, just take my word for it. There was no intermediate appellate court. And we ended up at the Supreme Court, and the Supreme Court said, we have a statute that says, if you're a journalist, basically, you can't be forced to disclose your sources. It's a really good, and it's been there for years, long before I was around. The Supreme Court said, yeah, that's the law, but it doesn't apply if you witness the crime. It can be called, and he witnessed the crime. Now, the time that decision came down, Brandsburg had moved out of the state, taken a job, I think, with the Detroit Free Press. He was up in Detroit. They couldn't figure out how to get him back. He's never testified. They never found out who the source was. But it changed the way, for example, I reviewed stories and changed the way that we gave, what advice we gave to journalists. And that is, if you've got a confidential source, he can tell you what he did or she did, but don't witness the crime. Don't witness the crime. Don't go there. And that's worked pretty darn well, because I've never lost an issue on confidential sources. I was sitting in the Supreme Court shortly before my 27th birthday, second chair to, it was really neat. And what the other thing, which is just neat for me, was I graduated second in my class at Penn. The guy I graduated first was clerking for Justice Marshall at that point. And I got to meet Justice Marshall. That's pretty neat. I got to see the basketball court at the Supreme Court. So it's but we lost that case. But it was it really was a win, because there was enough there that we could, from a concurring opinion, that we pulled it off for a long time. I think there have been instances at other states, one with the New York Times, that have weakened the idea of confidentiality. But that is, I think, basically it still holds true in Kentucky.
After discussing these really important cases, what would you leave with the listener in terms of, like, why are these open records so important? Why do we need to learn about them? Or how do they apply to us today?
Well, let me give you an example, because it's easy to say, well, you need to know what's happening, and everybody has a right to know what's happening. I had a major case against the state of Kentucky involving the Cabinet for Health and Family Services, involving records relating to kids who've been abused, killed, or seriously injured as a result of abuse. The Courier and the Herald Leader brought that case together. And to me, it was an open and shut case. And again, I'm going to get technical a little bit, but it's not very technical. There's a federal statute that says if you want certain money, substantial money, to fund the efforts of basically agencies like Cabinet for Health and Family Services, you have to agree that records relating to to kids who have been abused or who have been killed or substantially injured are public records. That's a federal law. The next year, this is 20 years ago, the next year, Kentucky passed a law saying they're open. And we went and we made a request, and they wouldn't give us anything. They wouldn't give us anything. And we sued in Frankfurt, and that's when the governor was Steve Beshear. And this is something I got ideas, but I can't really explain. He was adamantly opposed to disclosing any of this information. This is where we heard about a lot of rights of privacy. Kids been killed. In the middle of that, as that case was going on, there was a situation down in southwestern Kentucky involving a young girl named Amy Dye who had been killed. She's 9 years old or 10 years old or 11 years old it was a mixed family. So it was, if I say a stepbrother, it's probably technically not a stepbrother, but I'm not sure. But she had been killed, and that was a family that was under the supervision of the Cabinet for Health and Family Services and had a file on it. The newspaper down there, the small newspaper, made a request for those records. The Attorney General said they're open. Made a request for the records. The Attorney General, the Cabinet said we don't have any records related. They came back with, we don't have any records. Well, we knew there had to be records. So we filed a lawsuit. The Attorney General said you have to give those records up because the Attorney General thought that there had to be records also. We filed the lawsuit, and in court they said there are no records. They told the Attorney General we don't have any records. They told the court they don't have any records. We had a hearing a month later on something, and they came in with 3 inches of paper and said, "Judge, here are the records. We want you to decide whether we have to give them up." And I'm sitting there thinking, I actually sort of went crazy. And I was in front of Judge Shepard, who knows I go crazy sometimes, and I just said, this is an outrage. This is an outrage. They told us there were no records. They lied. They told the Attorney General there were no records. They lied. They told this court there were no records. They lied. Now they're saying this. And Judge Shepard took the records, and I think over the weekend read them and put the entire file in the court record, which was public, the entire file. He just basically not only said they're public, but screw you guys, they're in the court record, which is public. So everybody knew about Amy Dye, and it was an outrageous situation. She'd been locked out of the house. Her brother or stepbrother, whatever he was beating her with a snow shovel or something. It was really, it was horrible for them. It was a great case for public opinion. It was a great case. And what had happened was when the Attorney General ruled that they were entitled to it, and then the agency sued the little paper in southwestern Kentucky, I called the publisher and said, I'll do the case. And he said, I can't afford you. And I said, yes, you can, because I'm not going to charge you anything. If we get anything, it'll be court ordered. So the Amy Dye case was brought in with the big case, consolidated, and we ended up at the Phil Shepard, the judge. We won that case, lock, stock, and barrel, and we got, between the two papers, between penalties and attorney's fees, he ordered something like $1.25 million, $1.5 million. That's a huge. We never got penalties before that. We never got, and both laws have a penalty provision as well as attorney's fees. They appealed, and we won that at the Court of Appeals. And then, and that's a decision that continues to be cited, because there clearly is. What happened was we got the files, and the files showed that the agency was covering up for themselves, which is often the case. Amy Dye They ignored what was going on. They got calls from teachers about Amy Dye showing up with BB gun marks all over her. They just ignored it. We must have had a dozen cases where they ignored everything that was going on. So we got that was a topic of public discussion at the General Assembly. It was a topic of public discussion generally. The law was changed. Heads rolled, and we got and the public was really served. Now what happens is people forget. So you got to go keep asking for this stuff. They don't. There's a board that was established, a commission that was established by the legislature. Another long story, but until it happens to you, you don't care. But when it starts to happen to people in your neighborhood, then you do care. And I think that holds true, for example, with records relating to discipline of law enforcement, to cops. Bad cops. How are you dealing with them? What are you doing with them? And the law enforcement continues to fight that, despite decisions by the Kentucky Supreme Court that we're entitled to most of it. But you need to know how they're operating. You need to know what they're doing, and that's the best example I know. But I know I know a lot of agencies don't do what they would have done 50 years ago because they know it's going to be public. They got to explain. It's one of the problems we're having now, by the way, with public meetings and public records, is that a lot of the business and conversations is being done by text messages and the equivalent of electronic messaging, which I'm not an expert in, and everybody's using their own little phone to do it. So they say if it's on what they want to say, well, I did it on my private phone, but it's public business. So we're not at the Supreme Court on all that stuff. But if you want to know how how the cake was baked, you need to know the discussions. People, board members are sitting there at a board meeting texting each other instead of talking out loud. Well, we ought to be able to get the text messages. To me, it's pretty simple, but and we do sometimes, but we have a case pending now against the Jefferson County Schools. They had a problem with busing, the busing system breaking down last year, 15 months ago, at the first couple days of school, and everybody was instructed, don't send emails, do text messages, because they were trying to hide from the public what was going on. In the meantime, first graders were getting home at 10 o'clock at night. That's how you put public pressure on public officials. You go public with it. So yeah, I think it's been very effective. Our laws, I think our laws are rated very highly in terms of compared to other states, but mostly because we've litigated and we've fought on this thing. That's a problem because it costs money to do that, and all media organizations are having problems with money these days. It's an economic issue.
Well, we want to thank you so much for coming on this episode. I think we also both want to thank you for all that you've done for the Kentucky Kernel, for student journalism. We are both very appreciative.
Well, let me. I appreciate that. Yeah. Thank you. Let me just say one other thing, and I've said this publicly before. I think in the last 5 to 10 years, some of the best journalism in the state of Kentucky has been student journalists. Here, Eastern Kentucky's had some university. It's all been. It's why. I'm a big believer in. I hate to call it pro bono because I don't think I'm giving away. But I've done all this stuff for universities because I really like it, and it. You guys can't afford me. I'm not sure I can afford me, but it is important that when you're an active student journalist, that you're able to say, I've talked to my lawyer, and I've always said, use my name. It carries a little weight. And I think it's I love what student journalists do because as you get older, you get more cautious. And I don't like caution. I like going right ahead and striking. So it's it makes life fun. It makes it interesting. So I appreciate the opportunity of working with you guys.